For tonight, we could talk about 1L and how it differs from undergrad. We could talk about how to prepare yourself and set yourself up for success 1L semester with first year law school grades. And we could also cover a bit about law school exams and how they differ from what folks might have experienced in the past.
Sure.
And then anything else at all, of course.
Awesome. Okay. I think I've mastered all those topics. So
yeah, I imagine you talk about those quite a bit.
I've been reliving the horrors of 1L for the last 20 years. So yeah.
Oh God, I feel sorry for you, man. But I guess you get to pay it forward, right? You get to help others along the way.
At least I have all my hair, you know? I mean, it's a bad Supercuts haircut, but it's all there, you know? So why don't we do, I mean, the first question is a good one, right? Because law school is like no other animal in terms of any other academic experience that you may have, you may encounter, right? The teaching and testing methods are entirely different. So let's start off on the teaching methods in law school. So in law school, students are taught via the case method. That's the prime pedagogy. Actually, let's flip it around a little bit. In undergrad, most students are expecting, are used to the teaching method, which is your professor shows up the first day or two of lecture, sits on the edge of the desk, talks about how cool their summer was, what some of their research is, and then if it's a class like European history, right there, they'll talk about, okay, we're going to cover European history from the 1800s up until the Cold War. And we're going to talk about the Napoleonic Wars. We'll talk about, Bismarck, the building of the German Empire. Then we'll jump into World War I, the Great Depression, World War II, and then ultimately the Cold War. And for the next, 13 weeks of the semester, your professor will, show you how the roadmap she gave you at the beginning of the semester lines up with her view of European history, right? In law school, you get none of that. Right? In law school, you're, again, being taught via the case method, which means that your professor shows up, you'll show up for the first day of contracts class, let's say, having read a case. And they'll say, hey, Steve, let's talk about this case. It's Lucy versus Zemler. A drunk farmer goes into a bar and he bargains away, or he bargains for the Ferguson farm. And the question is, based on these facts, was there a valid offer in contract? And, through classroom discussion, maybe you or, a fellow classmate, but not very much lecture by the professor, you'll be able to distill that case down to a fine point of law. And then what happens is you'll read other cases throughout the semester or throughout the year, if it's a full year class, that build upon the law that you've already learned. So if you've done your job correctly and the professor's done their job, then at the end of the semester, you receive that overview of what the law of contracts looks like, all right, or the forest of tort law looks like. So it really is, the pedagogy is almost has you, wandering through a forest, right, randomly planting trees, and then ultimately at the end of the semester, you look back and say, okay, that's how the law of contracts fits together, or that's how the law and all the rules that we learned in tort law fit together. So, that in and of itself, the teaching method is really, really frustrating for a lot of students. There's not a lot of big picture. It's you're instantly thrust into the weeds, always looking up saying, okay, I see sky, but where am I, in relation to the other weeds and or trees and the overall forest?
That does sound really difficult. So it's kind of like we have all the complexity and chaos of the real world with the real interactions and everyday experiences that people have. And then at the end of the semester, our job is to extract the general principles or rules that might underlie how the cases were decided. So
actually, it's done on a daily basis where you're distilling down and pulling out the individual rule out of each case. So I should also just step back. For anybody who's obviously the audience, I would assume is people who have not gone to law school. We use the case method because America has a common law system, all right, which means that most of the law that you learn comes from cases, not some statute. Very rarely will you have a class that relies heavily on a statute, or even, even a constitution, which is like the meta law, right? Mostly you're reading cases where one party feels aggrieved, they sue another party for some kind of damage, whether it's monetary or it could be criminal law, where they're the state is suing a particular defendant, trying to lock them up and prosecute them. But what will happen is the judge will be presented with a set of facts, and the judge will then, based on those facts, have to craft a rule of law. So it's hard to imagine an entire body of law like contract law or tort law or criminal law or property law evolving from individual cases, but that's how it happened. But at the same time, as I tell our students, first off, none of this is a mystery, right? It's not that hard, right? And we've never really met before, save for one conversation, on the phone. But I'll throw a question out to you, like, have you ever been sued for breach of contract?
No, I haven't.
Okay. Have you ever been sued in tort?
No.
Okay. How is that possible? How, like,
it's a funny thing, yeah.
What?
It's a funny thing because obviously people do have disputes in the real world, but they typically resolve them before it gets to legal matters, right? Legal means. Or
of course, you could not violate it. You could just act rationally, not violate anybody's contract rights, right? Or property rights, or tort. Commit a tort. I didn't ask you about criminal law because we were all.
I appreciate that. Yeah.
One time, alcohol was certainly involved, I'm sure. But so none of this stuff is really hard. It's just that in law school, what you're learning is legal theory, right? So you're learning what the rules are, but more importantly, you're learning why we have those rules, because the law is not static either. When I went to law school, back in the 90s, there was no internet law, or cyber law, right? Al Gore hadn't even finished the internet by the time I was, getting through law school. So but what'll happen is you'll have the rules of contract, from these cases that come from the 1600s up to the 1800s, up to the mid 1900s, up to the early 2000s, and then boom, all of a sudden you have a very expanded and developed body of contract law. But you're met with a new medium. How do we handle contracts made over the internet? Can a contract be made by email? Can it be made by text? When you swipe right on Tinder, is that a promise that could be enforceable? Like whatever, right? There's all these questions that, old questions. So old areas, well-established bodies of law then get applied to new factual scenarios. And that's all you're doing as a lawyer, right? You're learning the foundation. You're learning the legal theory for these rules of law. And then you're presented with a new hypothetical or fact, which is sort of like the law school exam. And we'll get to that one in a second. But if it wasn't that way, if the law was static, then you don't really need a lawyer, right? You would have well-established cases and and there are jurisdictions that do that. If you want to go and live in France, it's a code system, right? Where they have a big book, and if your claim does not fall within that book, then you can't sue in under French law. Where one in America, somebody's donkey, kicks another person, right, and they sue, and then somebody's goat kicks another person, and they sue, and then ultimately somebody's dog bites another person, and they're relying on the rules that came before to establish, okay, now we have this new factual scenario. How do we handle it? Well, let's look at how we handled in the past, and then we'll apply it to this new medium, whatever it is, whatever the facts are.
But I suppose part of what makes it so complicated is that every case is slightly different. There's the dog, there's the goat, then cars are invented, then there's the Roomba that's invented, right? So like every case has a slight twist to it, and then we're going to have AI with computers, right? Someone asked in the chat here about internet law. Is that something new that we have to learn? And I suppose the answer is yes, right? Because that's the world.
Eventually, yeah. If you want to be employed, right? Yeah. Yes. Internet law is definitely something. Cyber law is another topic, and like I said, it never existed. When I was in law school, but then you can't step foot on a law school campus and not have those courses offered right now, right? And there's space law courses at some law schools now. So thank God for that, right? And those are upper level electives. So don't worry about it. If you don't want to take them, you don't take them. But do so at your own peril. Because eventually what you'll have to do as a lawyer is feed your family, right? And put braces on your kid. And unless you're like addicted to eating ramen noodles and, your entire family loves them as well, you'll want to, feed them well and feed them healthy. So you'll want all these new mediums and these new facts to develop, and hopefully you can become an expert in one of them.
Yeah.
So that's the teaching style, and that's how the teaching style differs in law school. And then the testing method is entirely different as well. And I say this not as an elitist, right? I didn't go to a top tier law school. When I went to I went to Albany Law School, which is a strong regional law school, but it was third tier law school. I like to say it was the very top of the third tier because by the time that the U.S. News and World Report rankings got down to the third tier, they just listed them alphabetically, and Albany was right at the top. I will say that having gone and studied at a school like that with a regional reach in a strong practical emphasis on the practice of law, you really have to make sure you're doing well, right? In terms of your first year grades, right? And you have to develop a approach to that. And part of that is really understanding how the exam is different from anything you saw as an undergrad or even high school. So, by way of example, in high school, you might have been tested on, and I'll go back to history because I was a history major, so entirely useless as well. I also, could have majored in wiffle ball, but maybe that's why, I ended up at a third tier law school. For history, like in American history, you might learn, in high school for Civil War, you might learn the battles of the Civil War, right? And, what your job is as a student in high school is to, memorize the dates of the battles of the Civil War and go back in on your quiz or on your exam and regurgitate back those battles, right? And then depending on how many you get right and, the percentage, 85% Steve, you get a B, right? Congratulations, right? In college, it gets a little bit more sophisticated. The question might be state the various battles of the Civil War. You've studied them, state them, and explain their significance in the overall war, right? In law school, the question would be entirely different, right? In law school, it would be, okay, you've studied all the battles of the Civil War, right? Now it's the winter of 1863, and you are placed in charge of the Confederate Army, and they want to invade the North. All right, develop a battle plan based on what both in terms of the military strength of the Union at the time, the weaponry available. Develop a battle plan for invading Philadelphia. And you're like, what the hell? Like, how is that? That's nothing like what I learned. And the difference is that in law school, you're not rewarded at all for rote memorization and regurgitation, right? Pretty much everybody who goes to law school, in your class is going to have the same brain power. That's just a fact of the matter. You applied to a college, you had a certain number of applicants who came in by expectation of the university and by the way the lots are drawn. There's a certain number of students who are, just not going to take it seriously or who are just, skated in there and not really, exercise their brain power to get the most out of college. The folks who go to law school are pretty much all the folks like you who did well, and now you're sitting in a classroom with them. So testing somebody on, okay, Steve, give me the 4 elements of negligence, right? Or recite the 5 elements of adverse possession of property. Like, there's not a lot of value to that because you don't. No client will ever come into your office and be like, hey, can you tell me the 5 elements of adverse possession? Or give me the 3 elements of an enforceable contract? Like, no one will ever ask you that question. What they do is they come to you with stories. And they tell you a story about crazy things that happen. You might have a little old lady who comes in and drops her, her purse on her knees and starts regaling you with a story about, how she met her husband at the USO in Newark, New Jersey in the 1930s and how they have 18 grandchildren. And they, he lost his hearing at the war, and you're sitting here like, lady, come on, this is a free consultation, but like, let's move this thing along. And then she's like, and last week he was walking across 6th Avenue in New York and he got hit by a FedEx truck. And you're like, what? A FedEx truck? Like, that's a deep pocket. Like, great. Okay, we could sue FedEx, right? So, and that's what you're doing. So the exam is actually designed not to test your knowledge of the law. 95% of your classmates are going to walk in with the exact same knowledge, working knowledge of the law. The exams are written, a hypothetical fact pattern, 3 to 5 pages, that, basically ask you, at the end of the hypothetical where people are doing super crazy things, discuss the rights and liabilities of all the actors under contract law. And you're there to take the law that you know, apply it to the hypothetical fact pattern that you probably haven't seen before, right? It's the new, you learned the rule of contract from the 1800s. Now we're applying it to the internet, right? And then make predictions as to how a court would turn out under these facts, right? Really, really different way of being tested. So those are the two major things. And I would throw in the third, and I touched on it a little bit, is that the competition in law school is kind of fierce, right? It's everyone is has the same brain power. You're graded on a curve, so that's foreign to a lot of students. So basically, what happens is the employers want to know, hey, don't waste our time, letting us interview the entire class to find the students that we want to come and work at our firms or work in our office or work at our courts. We only want to see the top 10% of the class, right? So in order to do that, law schools have a forced curve during the first year where only a certain number of A's can be given, only a certain number of B's, C's and D's, and even F's. So for the first time, a lot of students, depending on where they go to law school, if they have a C curve, they could experience getting a C for the first time in their life. Because it's not about me going in there, doing an information dump on the paper, and you looking down the suppressor and saying, okay, well, Don knew 85% of this material, therefore he gets a B. It's more, Don knew this much in relation to Steve, therefore he gets a B, right? So it's a really entirely different way of grading. So the teaching, testing, and grading methods typically throw a lot of people.
That is really something. And it's kind of funny you bring that up about the fierce curve that law school has, because a lot of times for the LSAT, people are shocked at how poorly they do on a percentile basis. But
Right.
Again, the competitor pool is once again a lot more fierce. Even when you're applying to law school, it's a more competitive applicant pool for law school than you would have applying to undergrad. And then it gets even more fierce when you actually are in law school, because not everyone who takes the LSAT actually makes it to law school.
Right.
Now, and imagine the bar is even harder after that. So it kind of
the bar is 3 years down the road. Do not worry about the bar.
nothing to worry. Yeah, true. Nothing to worry about at the moment. Yeah, just make it through 1L first.
Right. And once you start talking about percentiles, like to a lawyer, my eyes glaze.
We're all lost. Yeah.
And I'm like, wait a minute, hold on. He's talking about math now? I don't know. I went to law school to avoid math, so
right.
I just I know the curve and I know which side I think you're supposed to be on.
Right.
That's whatever side you're on of that bell curve is what you want.
Right. The other interesting thing that's sticking out to me is this parallel, once again, between the LSAT and law school with principle and application. Like
Right.
in the LSAT, we have logical reasoning section with fact patterns. You have to spot the issues, extract them, maybe take a general principle and apply it to yet another situation.
Right. Yeah, no, that's exactly, and basically that's what you're doing. With case law analysis and synthesis, you're taking various rules from different cases. You might have the drunk farmer on this case. You might have the guy playing a joke on his friend on this case, and then saying, okay, how do you meld those rules into one rule that covers offer in contract? And it's tough, but it's doable. I mean, it has to be doable. And again, the nice thing about it is, in law school, where students struggle is up until that point, they've only survived with a yes or a black and white yes or no answer, right? In law school, the answer is always, it depends. It depends on how you look at those facts. It depends on how you read these facts. It depends on what A was going to do in relation to what B did, right? So all those things, I mean, the tool chest for a lawyer is, consists of three tools, essentially: factual, legal, and policy arguments, right? And making those arguments is their craft. So, you look at a great lawyer like David Boies, he can convince anybody of anything, right? Arguing a certain way, whether it's factual arguments. In fact, a fact argument, or a good example of a fact argument, I should say, is imagine you're indicted for murder, right? And your factual argument is, hey, I wasn't in New York at the time of the murder where it happened. I was in Philadelphia, right? Very strong factual argument, right? A legal argument would be, you're indicted for murder. Yeah, I killed the guy, but he was coming at me with a knife, right? So you have a legal excuse, a justification of self-defense, right? And then a policy argument, needs to go in strength. A policy argument that a lawyer would use would be, you're indicted for murder. It wasn't self-defense, but your argument is going to be, look, I did society and the world a favor. This person was going to grow up to be the next Hitler, right? So, obviously the weakest of the three, still an argument, but all furthering different parts of the criminal law in terms of justification for acquittal and or some kind of a lesser degree of homicide. So those are just three tools that a lawyer learns, and what you're doing throughout the entire first year is collecting those arguments and then just waiting to be presented with a new fact pattern where you've got yourself a square peg, and it's got to fit into a round hole. And how do I shave those arguments down so they all fit?
Wow, very interesting. So in law school, are students actually on their exam and the exams and their essays, are they actually applying each of those three kinds of arguments? Typically. Or do only some all three apply?
Typically, obviously, as a lawyer, you're going to make arguments in the alternative, right? Steve is not guilty. However, if he is guilty, we still have a good excuse, right? You're always making these arguments in the alternative. So to the extent that they exist on a typical fact pattern, yeah, you would make those arguments. Oftentimes, and the other thing about the hypothetical fact patterns that are given on the exams is they're purposely written with ambiguity, right? They're ripe, I should say, ripe with ambiguity, because the professor, again, is not testing your knowledge of contract law or tort law or property or criminal law or constitutional law or civil procedure. They know you know it, right? They know you've memorized it. Now show me you've mastered it so much so that you can apply it. And each one of those, where a lot of students get locked up is, oh my God, I see the ambiguity, but it's really just easy to just ignore that and go with, he's guilty, right? Or he should be acquitted, or there's no liability, whatever type of case it is. The true hallmark of a good exam, the true great A+ student, is somebody who can identify that ambiguity and embrace it, and then just ring it out, right? Let me tell you about this guy's arguments are going to be really strong here. However, the other side, professor, because you were so clever in how you wrote this exam, is going to have these great arguments as well. And at the end of the day, the conclusion could be, who the hell knows? I don't know. I think B has good arguments, but maybe A should win based on, the overall policy of, do we want to reward that kind of behavior? It's really, at the end of the day, the conclusion, whether somebody is right or wrong. I've walked out of exams and I did the thing that you should never do on after a law school exam is ask your classmates, so what did you think? What did you get? Right? Because it's like the LSAT, right? It's like, who walks out of that exam feeling like they killed, right? Only people probably who fail, are oh, that was easy, nothing. And you're like, okay, good luck. Good luck to you. But I had people say antitrust exam. And one of my best friends, I was like, what'd you think there? I told him that the FTC should lock the CEO up for trying to do that merger. It was completely illegal. And my friend was like, no way, they should be commended. They should have been given an award for that. And we both got A's, because it doesn't really matter which way you come as long as you identify the issues and then argue both sides.
Dude, it's so funny. You're actually making me want to go to law school.
Don't. Wow.
I never went to law school. I got stuck with the LSAT and stuck with that never continued on my journey. But the ambiguity that you're talking about with these fact patterns is so interesting to me, because what you're getting at is that the conclusion that you argue for is not nearly as important as the way in which you go about making a reasoned argument. And the real world's complicated. Things aren't black and white. I think the nuance is what they're looking for to see that you can recognize.
Yeah, absolutely. And the other thing about these fact patterns is they're 4 pages, right? You have an hour and a half or 2 hours, maybe 3 hours to complete the exam. But for that one hypothetical fact pattern, you might have an hour and a half, okay? These questions could take weeks to analyze. So it's a high pressure, high stakes exam, right? And the professors know that. So, at the end of the day, the ultimate conclusion, like if given a law library and all of the billable hours, it's so funny because, in law school, you're taught to be really good with your time on an exam, but in practice, you're rewarded for inefficiency because you're billing by the hour, right? So, it's the exact opposite. But what they're trying to do is replicate what happens in practice. That client comes in, tells you this crazy ass story, and you're supposed to, most law school exams are open book, right? So you can bring whatever books you want. But again, as I tell students, it's like, a student who brings a book to a law school exam thinking that they're going to use it, they're a fool. I mean, because every second that you spend looking up an answer, right, that you could have memorized before is another second that somebody else is writing, right? So you treat the exams like they're closed book exams, but professors know that these hypothetical fact patterns are written in such a way that it could take weeks, literally weeks, to fully analyze the question. And all they want to see is, can you quickly identify what are the legally significant facts? Because the question is not going to jump out and say, am I a contract? Or was there a breach? It's just going to tell you a story, and you're going to say, that's a breach, right? Or that's failure to perform, or that's substantial performance, or that's, requires, restitution damages, or that requires, expectation damage, or whatever, just because of the facts.
So I guess what you're referring to then is issue spotting, right?
Yep. Yeah. So issues, I like to tell students it's not really issue spotting, it's dispute spotting. So if you're able to identify the overall dispute, usually what will happen is one of those elements. So let's say there are 4 elements of an enforceable negligence claim, right? Your slip and fall, somebody hits you with a car, that kind of a negligence claim, right? There's a duty, there's a breach of that duty, there's a causation, so that breach caused some kind of harm, the 4th element, right? And usually what will happen is the story will piece together 3 of those elements pretty well, but the 4th element, the missing element, whether it's the causation, or whether it's the actual breach, or whether it's the harm, or did the person even owe a duty, right? That's going to be kind of hazy, right? So the dispute is negligence. The issue is that discrete issue, or that discrete element that you're going to be arguing with. It's literally, I tell students, when you think of the word issue, it's where the parties will literally take issue with one another about the facts of the case.
Okay. Good to know. So I think you've given us a great overview of what law school is like and how it's different from undergrad.
How many people have we lost? Because now I'm thinking holy Christ, I'm scaring these guys.
No, our audience numbers are only going up right now. So apparently they like what you're saying.
Good.
So we've identified the problem, and now I suppose folks have some questions, but also obviously we want to get to the solution of how to prep for this, given that we're in the spring right now. Folks are looking to probably start law school this fall, or maybe if they're gunners, they're looking to go next fall. Right. And so I guess the question is, how do you prep? Do you study law first? Do you study how to study? What can someone do this summer before law school?
Well, let me take one step back and just cover something that you covered, at the beginning, to tee up why you'd want to prep for first year. And that's the importance of your first year grades, right? So 1L grades are by far the most important grades you'll receive in law school. And the reason is pretty simple. Again, as I mentioned before, an employer would come to a law school and say, look, do not waste our time. When I used to interview, by the luck and by the shock to everybody who knew me, all right, growing up, mostly my family, all right, after my first year of law school, I was number 4 in my class, okay, which, got me that big job that I thought I wanted in Manhattan before I realized, like, wow, there's got to be a better way to use my law degree than, you know, making Fidelity even richer. But, you know, when I was practicing law, I would go and sit in a, you know, conference room every fall, and with myself and another associate, and go interview students, right? And, you know, the idea is, don't waste our associates' time. You know, these two guys are billing out at $400 an hour. That's $800 an hour that's sitting in a library somewhere. Don't waste our time. We won't waste your students' time. Only send us students who have these criteria. They're the top 5% of their class, so the top 10% of the class, and they're on law review. Okay, law review is a quasi-honor. It's a student-run publication. You know, typically synonymous with, you know, people who are at the very top of their one-on class get an invitation onto law or some other journal where they review professors' articles. It's sort of like peer review articling, where a professor will, you know, a cutting-edge issue of law comes down out of a particular court. A professor will analyze it, and students will then edit that article and publish it, right? So basically saying, hey, look, this is where the law is going. Right, reviewing the current state of the law. So employers are very cognizant of, you know, their associates' time, and they're like, don't waste it. Don't waste our time, and don't waste, you know, our partners' time when you get called back to the office. We only want to see certain students, and usually it's cut on the first year grades. So the most selective legal employers, you know, will only really interview the very top of their first year classes. Okay. So that places a lot of emphasis on your first year grades. And I even go further to say, as somebody who's horrible at math, I at least could figure this one out. It's not even about your first year grades, it's about your first semester grades, right? Because you're front loading so many credits during your first year that if you're able to knock it out of the park in the fall semester, it is damn near impossible mathematically to catch you by doing well your second semester. If you don't do well your first semester and try to catch up, it's really hard, right? By contrast, you don't want to be in the group of people who don't do well their first semester and are trying to play catch up. It's possible, you know, but so is anything. You know, it's possible I might finally meet Beyonce, but, you know, and, you know, rap battle Jay-Z and win, but it's not going to happen, you know? It's unlikely, I should say. So in any event, though, like, that's the importance. Doing well your first semester is really key. So, you know, in terms of what we do, in terms of prep, you know, I recognize pretty early on that there's not a lot of, you know, study materials. If you wanted to try to buy a commercial outline for tort law or for contracts or property, or go out and buy a couple study aids that try to explain contracts in a nutshell, they're not written for an audience of lay people. Like, you really can't just sit down and say, okay, now I'm going to teach myself property law. You know, I guess there are people out there who can do it, right? But, you know, the overwhelming majority of those study aids are written for an audience of people who are current first-year law students, who are reading the cases, who are going to class, listening and participating in the classroom discussion, grappling with this law, and now just need some clarity. Like, they walked out of Monday's class more confused than when they walked in. What the hell was that professor saying? Let me try to figure it out by looking at a commercial outline. But for your average person to sit around, you know, go to Jones Beach over the summer, and, you know, whip out their manual law outline and start reading it, it's kind of useless, to be honest with you. So when we started Law Preview, you know, I designed it with 4 fellow associates of mine. We were all working at a large law firm in New York. I'm the only one who jumped ship. I'm the one who had the entrepreneurial bug to say, okay, I'm going to quit my job, and you know, sometimes felt like I tore up a winning lottery ticket, especially now. Like, one's a partner at Skadden, you know, one's a partner at Sidley, and I'm like, damn, what was I thinking? But at the same time, you know, like, you know, I also know my kids, so, like, it's a good thing. But, you know, when we were looking at what would be helpful for students is, you know, first off, to combat the case method, right? The pedagogy that I mentioned before when we first started out the conversation, that building block approach, where at the end of the semester you see what the body of contract law looks like. What we do is, if you're going to take the class, and you're welcome to come, Steve, if you want to, you know, sort of get the experience of law school, I'd love to have
Thanks. Yeah, sounds fun.
So we do it at Columbia. We have in New York, we have Jody Krause, who's a professor of contract law at Columbia. He's written a case book on the topic. So these are subject matter experts. And the idea is, I hire people, professors who regularly teach on the subject and who are pretty much recognized as experts in the subject, for the sole purpose of getting back to that idea that if you can really master something, you can explain it to a 4-year-old, right? And then I pack the room, with entering law students, most of whom have never been exposed to law, right? And Jody will then take them on a monorail tour of contract law, right? He'll start out with where contract law comes from. Here's why we have it. Here's all the major theories that are driving this area of the law. Here's how you form a contract. Here's how you, defend the formation of a contract, say that a contract was not formed. Here's how you breach a contract. Here are defenses to breach. And then ultimately, here's how you, collect damages if a contract was breached. And the idea is that after 6 hours, sitting in the room with an expert, having them really lecture and explain something, as I said before, that's not that hard, right? Again, because we know these rules internally. We're not out there breaching contracts all the time for a reason, right? Because we know the rules. We just don't know what they're called, right? Or we don't know why we have them. But what somebody like Jody can do is take you on this monorail tour of contract law and then have you look out the window and see a 30,000-foot view of contracts, right? So what that does, I sort of explain it, is like you're in New York, I'm up on the Cape. If I said to you, okay, before you leave your house tonight, you're going to drive up and see me. Would you rather me, surprise you every exit with a new direction, or would you rather have a GPS overlay of where we're going? Right?
Yeah, you want to see the roadmap ahead of you,
right? And that's all we're doing, right? So we're providing them with the forest of contract law. So when they're doing the cases, they're not doing it in a vacuum. They're reading these cases, they're distilling them down to a fine point of law and be like, this has to do with contract formation. It's coming here. It's planted in this part of the forest. I know damages is coming. I know breach is coming. But that's not until later. It's sort of like knowing the punchline to a bad joke. I'm right here in the forest, right? And this is where I have to stay. This is my dance space right now. So that's the substantive overview. And we do that with all of the classes. Again, written for an audience of folks who have no experience in law. It doesn't matter if they're paralegals or not, because again, as I tell paralegals, it's like the most dangerous thing to be in law school, because you walk in thinking that you know the law, and you do. You know how to practice law, but in law school, you're not learning practical skills at all. You're learning legal theory, and that becomes very dangerous. A little bit of knowledge can go a long, can become very, very dangerous, especially in the hands of a paralegal. So I know I'm probably getting comments now that don't bash the paralegals, but truth hurts. But then the other half of the class is a strategy component on how to do well your first year, based on everything, right? All the skills that you need in terms of case briefing, case law analysis, outlining, note taking. We have a 4-hour exam taking strategy lecture at the end of the week where you actually take a law school exam and apply the argument, the arguments that you learned in tort law, contract law, whatever the question is. So I like to tell students that, especially the first semester, when you walk onto a law school campus, the learning curve is not a curve at all. It's like a right angle, right? It just smacks you right in the face. And if you don't do any kind of prep, if you're not even prepared for the experience, that learning curve is very severe, right? And with so much riding on your first year grades, it's a tough time to be learning substance and skills. So while I can't eliminate the learning curve entirely, what I can do is I can make it a more gentle slope. I can make it a 15-degree slope, which is really, appreciated when the entire class is trying to play catch up and climbing up this learning curve that's a lot steep, and also has no game plan for how to attack the first semester.
No, well, it sounds enormously useful. I love the idea of being able to do a full law school exam before you actually start law school. And then I imagine you give them feedback also on what they wrote.
Better than that, we give them model answers. right?
Nice.
And they go through the exam with a real law school professor to say, okay, here's what I like, here's what I'm looking for. See how he does this. See how she did that. And they go through it. Usually, obviously, their work product, the student's work product is is what you would expect. It's a 1 week course. It's really less about showing them how to showing them the law that they've mastered in the 1 week. Although, shockingly, I've had students come to me and say, like, I learned more in this 1 week of law preview than I learned in all of undergrad, which, if their college career was anything like mine, where I basically just played wiffle ball and, was a history major, it's entirely possible. But usually the purpose of that exercise is really to drop them in a cold bucket of water and say, this is what a law school exam is going to look like, right? Here's how you take a hypothetical fact pattern and deconstruct it, and then reconstruct it into an A+ answer. It's a skill that, none of the stuff that we teach in Law Preview is something that people will never learn. Well, everyone gets it, right? It's just a matter of when they get it, right? And, some people will get it second semester. Some people will get it first semester, without a law school prep course. Some people will get it second semester. A lot of people start to get it second year. And that's when they come back and they're like, damn it, had you told me this is what you were looking for, right, I would have done it, right? Because again, law school is, the law is not that confusing, and law school is really not that hard if you know how to attack it.
Well, Don, it sounds like you're giving people a dry run so that they can make at least the bulk of their mistakes before they even start.
Yes, absolutely.
And back to what you said earlier, where like second semester, you're already playing catch up if that's when you start learning things.
Right. And that's an unenviable position to be in. You do not want to be there. Right?
What about the Socratic method? How important is it to be prepared for the cold calling?
I don't care.
Matter?
So I practice radical honesty, if you haven't guessed her. Okay.
Sure. I'm asking.
Why?
That's why I'm asking. Yeah.
Okay. So, there's certain things that I don't care about, and I'll tell students and they'll laugh, but I'll be like, no, I'm pretty dead serious. Like, after first year, I don't care if you buy the books or not. I don't care if you go to class or not, right? Law school is a 1 year sprint, not a 3 year marathon, right? So people who are running a 3 year marathon are running the entirely wrong race, okay? Similarly, I don't care how you do in the Socratic method. If you're scared of getting called on, so what? Everybody is. All right. Your entire class does not want to be called on. All right. Your professor walks in the room and everyone's eyes just drop. Nobody wants to be called on. Right. And then, it's sort of sharks and minnows, right? Somebody gets picked off. Steve, you're in the hot seat. Let's talk. And all of a sudden there's like a collective sigh of relief. You're like, ah. All right. But even there, like no one's like sitting there and being like, Steve, what a jerk, dummy. How did you get that wrong? They're all like, Steve, please get this right. All right, because they know that if like you get it wrong, the professor will be like, no. How about you, John, over there? And John's like, please, no, I don't want to be called on. So in terms of the cutthroatness and in terms of the camaraderie of law school, like you build your best friends in law school, even though you're competing fiercely with them against grades. There is that minnows versus shark mentality. But at the end of the day, the other thing that I love to tell students is how well you do on in class has zero bearing on your grade. So what do you care? Let's worry about things that matter. I have a philosophy that with my kids that and they're typical teenagers, right? They don't think I know anything, but I'm constantly talking them off the ledge that, hey, look, if it's not going to matter 5 years from now, we're not going to worry about it. Right? So like, save for you getting pregnant, killing somebody like in a car wreck, or, doing something stupid. Some things like that would matter 5 years from now. All right. But the bulk of what you're doing on a day-to-day basis is not going to matter 5 years from now. So lower your anxiety. Getting called on in class is one of those things. It has zero bearing on your grade. All the exams are graded anonymously. Right. So, the professor has no idea whether Steve Schwartz wrote the A answer or Don Macaulay wrote the A answer. You can't be the classroom or the teacher's pet. So by contrast, if you screw up, right, in your answer, first off, the professor is guiding you towards that, right? Because they want to make it a teaching moment, right? They want you to get your answers wrong in class so you're not eventually representing a client or standing up in front of a judge and making stupid arguments, right? They want you to be able to think through these things and think on your feet. So oftentimes the professor is leading you down a path for you to get it done, all right? But there's no shame in that. And again, it has no bearing on your grades, so don't worry about it, right? I mean, that's my philosophy.
No, that makes a lot of sense. The grades are what matters. As you said earlier, it's all about 1L in particular in fall semester.
I mean, the other thing about grades I should just say is, in law school, there are no pop quizzes. There are no papers to write. So the things that you had as a gauge for how well you're doing in, college or in high school, leading up to the final exam, that's worth 30% of your grade. In law school, it's worth 100% of your grade, right? So, there's not a lot of positive affirmations either coming at you on a daily basis. You're sort of like floating through this, like, am I doing this right? Do I have a system to understand? And that's something that we address, in terms of using the case briefs as a daily quiz to identify for yourself, hey, am I getting this? Like, do I have the confidence to walk into the final exam saying, like, I understand 90% of this material. I got it up until this point. I think I should be okay. Otherwise, you're sitting there walking in, like, depending on whether you're a pessimist, like, oh my God, I know nothing, or, I'm an optimist, like, oh my God, I got 100 on the exam and I can only lose points at this time. That's how you walk into a final exam that's worth everything. And that's another thing that, places a lot of pressure on students during the first year. And that's something to worry about. That's something that, again, will matter 5 years from now, because your first year grades, as I hit on before, really can change the trajectory of your legal career.
Right. I like the idea of those case briefs as like a regular check-in for where you're at. So you're not waiting till the end of the semester with the exam before you find out whether you know something or not.
Right. And I'm sure there's like 1,000 questions already being like, oh, my big brother went to law school and said I didn't have to brief a case. Well, whatever. I'm a little more old school, right? I basically, there's a correct way and an incorrect way of briefing cases, and there's a way that you can sort of use it as a daily quiz and check yourself. And that's what I'm more interested in for students.
Okay. And you could also say, well, what's the risk averse strategy? What's the practical strategy? Should you brief the cases, or should you just do nothing and wing it and wait till later?
Dude, I mean, and you sound like a lawyer, because lawyers are what? Risk averse.
Right.
That's
exactly.
All we do is manage risk, Right. That's why we I was thinking before we even got on this call, I'm like, how does this guy know I'm even going to show up? Like, he emailed me, I never replied. He emailed me one more time. Here's the link. And I'm like, this guy has there's no contract on my side. Like, if I didn't show up, I guess my reputation makes me want to show up. But as a lawyer, I would be like, Steve, Tuesday, Steve, confirm, Steve, I want it in writing, Steve, I will have your firstborn. If you don't if you don't show up, again, as a lawyer, all we're doing is managing risk, So maybe you should go to law school.
I had my whole juggling kit in the corner. I was just going to perform for everybody. You did.
A little magic.
A little magic show. Yeah. Awesome. Well, we've got some questions here from the audience. You want to dig into these a bit?
Yeah, absolutely. Let's go through it.
All right. So we've got one from Jordan asking, are there certain undergrad majors who may do better in law school? If you're a pre-law major, does that help for law school?
Not really. No. I mean, unfortunately, law is sort of like medicine, which I guess biology would help in medicine. Okay. But what I tell students, in terms of their undergrad, and my daughter's a sophomore at Oberlin, right, in Ohio. And my advice to her is enjoy yourself. Don't grow up too quickly. The most important lessons you'll learn in college are social skills. How to talk to somebody that you don't really want to talk to. How to deal with a roommate who leaves dishes in the sink. I mean, you want to talk about big problems, that's big stuff that you should be picking up in your 4 years of college. All social skills. But when you get to college, or when you get to law school, the stuff that you learned in undergrad may not really prepare you. There's, again, you could be an English major and have written a bunch of papers, or a history major. There's no term papers to write, right? A pre-law, I guess depending on what you're studying as a pre-law major, I guess that could impact. I don't know. My my inkling is to tell you, do what you love, right? If you do what you like, you'll, from a learning standpoint, it won't feel like learning, right? It'll feel like a hobby. And even a work standpoint, like you'll never have to work a day in your life if you're doing what you like. So where the undergraduate could come back in on, underneath, it's not to help you in law school. It's to complement what you do with your law degree, right? So like say, God please, all right? You're a computer science major, right? And you want to couple that with a law degree. Well, God bless you. Like I would implore that you either adopt me or take one of my kids, the one that we don't like, all right? Because you will have more money than God, because you'll be combining a knowledge of science and computer science, right, with intellectual property law, which is super hot right now, right? You can't find, an engineering or computer science background person who goes to law school. So if you can do that, by all means, like do that. Anything with the hard sciences, but if it interests you, but don't choose a major because you think it's going to help you in law school. It probably won't. Philosophy, maybe a little bit, but that's just a matter. I mean, you don't have to take a philosophy major. You can just take a couple of philosophy classes and understand rhetoric, and understand argument, and then be done with it.
And for law school admissions, you also have your undergraduate GPA to consider. Right,
exactly. So that's, again, if you're gonna take a course load of stuff that you think is just going to help you prepare for law school, but it's not of interest to you, then you're likely not going to do very well in undergrad. So I would just do the things that really make you happy, right? And then have a good time in college, because law school, as fun, it's a different kind of fun, but it's not the same kind of freedom fun that you will have. The 4 years of, there's certain things when you get gray hair like this, you start thinking like, damn, I got to live my life backwards because I've got some knowledge now. And I could have done some serious damage had I known this is how the system works.
Right. We got a question about BARBRI 1L Mastery versus Law Preview. What's the difference and what order should people do them in if they were going to do both?
Okay. So 1L Mastery is a study aid. Okay, so again, written for an audience of students who are currently in law school, grappling with the material. It's a series of review lectures on video. So basically what BARBRI is. So BARBRI acquired Law Preview, and now I'm working for the man.
You're like a gazillionaire now, right?
What's that?
You're like a gazillionaire now, right?
I wish.
Big exit.
I wish. My kids think so, but no, I'm not. So BARBRI is a company that is best known for a bar review course. So after you go through 3 years of law school, they run you through this 7-week program that says, hey, Steve, remember tort law? Here's what tort law is, and here's how they're going to test it on the bar exam. And these are all the rules you need to know. And remember contract law? It's been 3 years. Let me show you. Let me give you a quick refresher. It's a review class. So they put out a study aid called 1L Mastery, which basically is they take videos from their bar review lectures on torts, property, criminal law, all the first-year classes, contracts, and then they package it as a review lecture. So when you're going to study for your final exam, these are the rules of contract law, and this is what they are, all right? Down in the weeds. What Law Preview is a course. It's not a study aid. And in fact, if you take Law Preview, you get 1L Mastery for free. So please do not buy both, all right? But Law Preview, as I described before, is written for an audience of people who have not stepped foot on a law school campus, right? And it's to provide them with a really solid foundation of what contract law is, what torts, property, all those first-year subjects are, and how they look from a 30,000-foot view, and then the skills on how to attack the first year. So that's how they differ. Very, very different. But I mean, like, you can buy the 1L Mastery set. I'm sure you can buy them. I don't think it's going to make much sense, and it won't have much utility to you until about November, when you'll be like, oh, that's what they're talking about. Okay, now I see how that fits together with those rules, because they're really down in the weeds in those review lectures where you're just not ready for that. It's like not only running, it's like the 40-yard dash, to learning how to crawl.
Right. Thanks for that, Don. And we have another question related somewhat, and I was thinking this too. You mentioned that Law Previews live. You said it was at Columbia, but then there's also, you said it was written. and there's also apparently a recorded version.
Yes.
So there's some different options out there for folks, I guess, based on geography, but could you go into those a bit?
Yeah. And it's become more like, I always thought, I was the full resistor to, we're not going to do Law Preview online. You can't replicate the experience of, having somebody come and sit in the classroom with Jody Krause and, learn contract law from somebody like him, right? And then we ran a test last year with our first live stream session. So basically, I guess what you're doing now with we do a live stream, not through Facebook. It's through this web app where people were piping in to a class that we were live streaming from Emory Law School last year. And in an effort to obviously cut down on travel costs, a lot of people can't travel to the session, can't get time off from work. So they live stream in rather than incur these different costs, time or money. And it literally is just like being in the office. So now I'm like, damn, like, I don't know, do we even need to run these things live? Because even down to the questions, that the instructor is mic'd, really professionally mic'd. The room actually is mic'd as well. But then there's also, like, if Steve has a question, there's this this foam box that gets. Have you ever seen this? I'd never seen.
That sounds cool though.
Oh no! So like these kids are like, now I'm sitting here thinking like, holy shit, someone is gonna like hit in the head with this box, and I'm gonna get sued. Like now we're thinking about waivers, But like it's a foam box, and they throw it, and then as soon as it lands, like so in the air, the mic turns off, so there's no residual noise. As soon as it lands and stops, it turns on, and the kid asks the question. So it is literally like being in the room, and then to help students relate with the class, we have a student instructor, somebody who took Law Preview the last year, who did really well, right? So some of the questions, a hand will go up online, and the student moderator will either answer the question directly, like, oh, the professor said this, and this is what he meant, or oh, the professor said this, let me ask her. That's a good question, and that wasn't asked. Let me raise my hand, and then the student basically asks the question for the person online. It literally is like being. So that's the live stream. We run 2 of those. One earlier in the summer from Chicago, another one from LA. I do both of those. The only reason we don't do New York is I learned my lesson last year. I got too many complaints. The only complaints that we got for the live stream was, Jesus Christ, why did you have this thing on the East Coast? I'm waking up at 4 a.m. to take this goddamn class. And I was like, oh yeah, well, everyone was based on the East Coast. So we decided to run Central Time Zone. And then later in the summer, we have a Pacific Time Zone. So you can pipe in that way, or this year we're actually recording the first one. And you could, for lack of a better word, binge watch it during the summer. So there's an on-demand version for people who really can't make it. And that's for folks who can't work and, or who have to work but want to take Law Preview for 2 hours in the evening, because we only run the class from 7:45 in the morning until 5 in the afternoon. It's a long class. It is I will tell you again, the other only complaint we ever get from students is like, Christ, you really have to tell people how hard this is, because it's a lot of work. But we also have kids coming back and say, like, I was number 1 in my class, and I'm glad I did law school this way, because I was going to treat law school like undergrad, and quickly realized from how my friends did it, that would have been a huge mistake. Yeah,
well, better now than later, right?
Exactly. Yeah.
We got one comment saying, this is wonderful information and you're really entertaining.
Oh, thank you. Yeah. I was hoping the comment was going to be like, I was really hoping for, and you look like Bradley Cooper, given that damn movie. All right. As I said to the person as I sat down in the Supercuts haircut chair, she's like, what do you want? I'm like, my wife says I have to walk out of here looking like Bradley Cooper, so do your best. So thank you. I try to be entertaining.
Well, I guess if they want more, they should take the class, right? All right. So we got one question about moot court versus mock trial versus law review. Mm-hmm. Are these worth the time? Is it okay? Is it possible to do both, or is it too much of a drain?
Yeah. So all of those things are extracurricular activities that you will do during your second year, except for mock trial. Mock trial is the trial teams that usually take place during the third year. So moot court is essentially an interschool appellate advocacy competition where you learn how to argue an appellate case. among your, you pair up with one other person, you write the appellate brief, you write the respondent's brief, things you'll learn about, you don't have to stress out about now. And then you argue them before a series of judges. And depending on how far you get in the tournament, the judges might get more and more prestigious. You might have, a Supreme Court justice. I know that Scalia used to come down to Georgetown and be the final, one of the judges on the panel for the final round of Moot Court at Georgetown, right? Pretty cool stuff, right? But that's stuff that you don't have to worry about until your second year. The one thing I will say is that in terms of a legal career, you want to be on law review, right? Again, law review is that, student-run publication, which is, it's like a special club. Like once law review is on your resume, it never falls off. So the last thing, it's one of those things that, when you go for a job interview and they see that Steve, oh, you're on law review, yeah, he was on law review too. It's like sort of like, oh yeah, you're a member of the club. That's one of those things that you sort of have to do. That's if you get invited to do that, you don't make the decision not to. The two things, law review and moot court, are not mutually exclusive, so you can do them both. But if you don't have time for both, and again, you can think law review as a student-run publication. You can imagine that there's certain points during the semester where there's not a lot going on, right? And then publication time is coming up, and then you're always in the law review office. Same with moot court. There's certain parts of the semester where you're doing a lot of work, getting ready for your competition. But once you've memorized the arguments and understand your brief backwards and forwards, it gets a little bit easier. Or you might get knocked out of the competition earlier. It really depends. But if I were to say, like, if you could only do one and that's it, then you do law review. Because again, whether you were the octo finalist in the moot court competition at your school, it won't last on your resume very long. Law review will be on your resume until the day you die.
There's a certain prestige to it, I imagine.
Absolutely, yeah.
We got a couple folks asking about books to read before 1L. I mean, obviously there's but people are always asking what books are out there. I know that you weren't too big on the commercial outlines before starting law school. Is there anything else out there that you think might
I've got great ones. All right.
Awesome.
And these are written for a lay audience. And if you want some summer reading, write these two things down. The first one is written by, and this is a, patent endorsement of, full disclosure. He's a very good friend of mine. He's the dean of University of Texas Law School. His name is Ward Farnsworth. And the book is called The Legal Analyst. All right. And essentially, it's a really short primer about legal theory and how a lawyer thinks. And it's written, again, not from the not from the perspective of somebody who's sitting in a law school classroom, but sitting, if you wanted to understand how a lawyer makes argument, right? Understanding a little bit of game theory that it gets into, understanding the various types of argument and what a lawyer does and how they craft, their craft is words and how they use those words. Phenomenal book, written for an audience of people who are not in law school, right? So that's one. The other book is a book by the name of a Boston lawyer. It's called A Civil Action. His name is Jonathan Harr, Harr. And a civil action, as boring as this might sound, it's about a toxic torts case that takes place in Woburn, Massachusetts, where a lot of people were drinking the water, and this whole community got cancer, right? And essentially, this personal injury lawyer takes this case and takes on some very big companies, and who have done some horrible, horrible things, and they destroy him. Even though they did everything wrong and they deserved to be found liable and or even probably even held criminally liable in some instances. These big law firms just beat the hell out of this small personal injury lawyer. And the reason why I love it is, first of all, it was a movie. It was made a movie with John Travolta. Do not see it; it sucked. But the book is just fascinating in terms of, you'll take a class during your first year of law school called civil procedure. which is basically how a lawsuit proceeds through the court system. A civil case, rather than a criminal case where the state is bringing against the defendant, a civil case is a individual or corporation versus an individual or corporation, private citizens, essentially, right? Bring a civil action. And there's an old mantra in civil procedure, like, you can have all the facts and law on your side, but if I know civil procedure better than you, I'll beat your ass every time. And this is a perfect example of that happening. And it's also like a riveting novel. I mean, like, it is a total page turner. So those two books should keep people busy, at least through July. And then if you're not taking Law Preview, then, okay. If you do take Law Preview, like, we will have you fully prepped and ready to go. I would recommend doing nothing else other than, getting some sun, sitting your significant other down, explaining about what the next year is going to be like for you and why it's so important that they have to support you.
Well, thanks for that breakdown, Don. Those are both great reads that I've heard a lot about, but I actually haven't ever read myself. So
I'm telling you, if you picked up, it's not like it's not up there with like 50 Shades of Grey, I'm assuming. But it's as spicy as it gets for a lawyer. A civil action is a really good book.
All right, so those will be ranked 2 and 3 on my list. All right, we got a couple more before we sign off here. We got one that I thought was actually a really good question about 1L grades. So 1L grades, of course, are very important, especially fall semester. But you're applying for a summer associateship before you've gotten back all of your grades from the first year, no?
No, so usually, OCI, which is on-campus interviews, take place in early August, beginning of the second semester, right? So the timing of it is you go through your first year, you'll get your grades back from first semester sometime around middle of January, possibly early February, right? Presumably just after your spring semester check is cleared, they'll give you your grades, right? And be like, surprise, you're staying with us, I guess. So then you'll go through the spring semester, and you probably won't get your grades until sometime, mid-June, all right? And that's where, yet another thing that you could think about first-year grades being important about is if you want to transfer, right? So the option to transfer is something like, again, having gone to, where I went in terms of Albany, after my first year, I had an opportunity to transfer to NYU, right? Like, really do a crazy jump in terms of, the rankings of my law school. I didn't take it. Instead I took the law school actually gave me money, to stay. But one of the things that, we see a lot of students doing, I'm actually having a conference call with somebody tomorrow from Brooklyn Law School who killed it first semester, is doing really well second semester, wants to transfer to Harvard. We do that all the time. And we see that happening where students are starting out here but ending up here. Not that Brooklyn's not a good school by any stretch, but going to a school like Harvard opens up doors. I mean, it's not fair to say that it's in a different league. It's like literally in a different stratosphere in terms of the options that you'll have coming out of school. And that's presumably why you're going to law school, unless you're like an irrational actor or like a trust fund baby who doesn't care. What you're doing in terms of going to law school is to improve your situation. So a lot of students are using those first year grades in June and July after the first year to transfer to a higher ranked school that offers not just a higher ranking, just don't transfer for the rankings, but transfer for the options that you'll have. Whether you want to ultimately get a Supreme Court clerkship or ultimately you want to teach, there's 3 schools you have to go to in the country, right? Harvard, Stanford, and Yale. 50% of the law professors came from those schools. Every other law professor came from everywhere else, right? So that's the timing of the first year and the transfers. And then what'll happen is starting in August, you'll start bidding through your career placement office, or the Law Preview Job Network is something that we have as well, where firms will contact you and say, Steve, we'd love to have you sit down with 2 of our associates in the library or at a hotel in Manhattan. Come and spend a half an hour with us and interview with us. And that's based entirely off your first year grades, right? Entirely off your first year grades. They're not looking at anything else. They're not looking at undergraduate transcripts. They're not they don't care what's on your resume. It's based on, three things. The top three lines of your actually top two out of the three lines. They don't care about your name, right? But they care about where you're going to law school and what your class rank and GPA is, right? Essentially. So that's that happens in the fall semester of your second year, and then what you're doing is trying to get a job for the summer after your second year. And usually that process, OCI, results, on-campus interviews results in a callback interview, and by October or November you've locked that down, and you're sitting pretty with a job to go and work at the following summer, making at some firms, I don't know, $3,600 a week, which is clearly you're not impressed. Clearly you're a New Yorker, you don't care, right? You're like, oh, $3,600 a week. That's what I spend
one month's rent.
Right? No, I mean, like 36, but you can make 30.
That's a lot. Yeah.
Yeah, $36,000 over your 10-week summer associate position. That's like, for some people who don't live in New York City, that's real money, right? So.
Yeah. No, thanks for the breakdown though. It's good to have a picture of how these things come about, and obviously there's a certain cachet to the brand name of a particular school that opens doors, as well as just where you fall within the class. Right.
So, I mean, look, honestly, like I said, if I wasn't in the top 10 people of my class, I wasn't going to get the job at the big firm in Manhattan, right? But, if you're in the top 30% at NYU or Columbia, you would have that interview. So, but like I talked to a kid today who's going to Harvard, and, he was like, hey, I want to take a law preview because I really want to be, and I was like, well, I mean, like, FYI, if you're, I want to go work at a large law firm in Manhattan. I'm like, okay, don't kill yourself. Like, not that I don't want to have you come and take the class, but he's like, well, my bigger goal, and that's where is to finish here so I can get a appellate court clerkship that will lead to a higher clerkship, which will eventually have me leaving private practice for a number of years, but coming back as a corner office partner. Oh, okay, well that makes perfect sense, right? Those are the things those are the brass rings that the top students at the higher ranked schools go for. So there's definitely a pedigree. There's definitely a pecking order with all these firms and all the opportunities that come out of the various firms and or the schools that you go to.
What percentage of entering 1Ls do you think have done law preview or something not nearly as good as it, but in the same category, walking in to prepare themselves for law school?
So it's a great question, and I don't know why it's so small. All right, but so I would I know what the numbers are, right? We see about 15 to 1,600 students a year, right? So we're looking at a market size for a law school prep course of about 5%, right? Not a huge number of students are taking this, but I will say this. When BARBRI bought us, the CEO came to me and said, well, what can we do to get this from, 1,000 students or 2,000 students to 5,000 students? And I was like, well, let's, all we have is anecdotal evidence. Let's hire a third-party, research firm to, survey the students who took law preview, find out where the hell these people are. How'd they do? What was their class rank after the first year? Did it have an impact, right? And so they went out and, I was too cheap to hire this one, to do this when I was owning the business myself, right? We ran a very, very close company and, very close to the bone. You're an entrepreneur,
Sure.
But, somebody else, a larger company wants to do this research, be my guest. So we hired a third party outside organization to do the research and the survey and analyze the data, and, surveyed about 5,000 kids who took the law preview course over a certain number of years. And, the median class rank, so the median class rank of students who took law preview was the top 16th percentile, all right? Wow. So again, I'm not a math guy. I was thinking like, whoa, like, what does that mean? I think median, I think average, I don't know. Like, and they're like, no, this is like, you're moving the needle. But then like other, indicators of success, like 63% of the kids or 66, the numbers are on the website. But 66% of the kids ended up with a 2L summer clerkship, right? 33% of them ended up a research assistant or a professor. Like all these hallmarks of first year success, like getting a job, working as a research assistant for a professor, which is that's the best job to get as a 1L summer associate. One thing that I never understood, or I didn't realize it until BARBRI acquired us, because they're the master of the bar exam, right? Is the fact that we had a really high 80 or 90% bar passage rate, which is pretty high. And it was explained to me by the folks at BARBRI is, it makes perfect sense, because the best correlation to how well, to whether you pass the bar exam on the first try, is how well you do your first year of law school. One, the subject matter is pretty much the same subject matter that's being tested on the bar exam. And two, it's almost the same replication of the stress that you're under during your first year. If you can manage that first year stress, you can manage 7 weeks of studying for the bar exam, which is okay, that makes perfect sense now, hindsight. I just never thought about it. So there's all these markers of kids who do it. Now, you can, I'm sure there's skeptical lawyers out there, which, good, you'll get paid well for this in the future, that say, well, you're not really statistically correct, because there's probably a self-selection bias of people who were going to take a course like this that are going to do well anyway, or a self-reporting bias, which they're not going to tell you if you did bad, but they're excited to tell you that they did well, which the researcher said was, I didn't think of that. I'm not a statistician. What the hell do I know? I'm oh, really? I wouldn't even know that was an issue. But they said, even accounting for that, having a median in the top 16th percentile is really remarkable. So even if you were even if we took a median from, because by definition, I guess the median should be 50th percentile. Even if we took it from 50 to 40, that would be incredible. But the fact that we got the median class rank is in the top 16th percentile is pretty amazing.
Well, regardless, it sounds to me like you would want it, given the massive investment one is making in law school. I saw one calculation that, given the tuition and the opportunity cost, it's something like $300,000 all said and done. Now, law school tuition alone is maybe $50,000 a year before accounting for any merit aid, but I'm guessing Law Preview is a small fraction of that cost.
Yeah, no, it's $1,300, and plus, half the students don't pay for it. Half the students get picked up by, by sponsors. So we'll have, depending on what law school you go to, and you can imagine there's also a pedigree there, right? So the higher ranked schools have students who, might be more attractive to some firms than other schools, right? Simply because that's where their partners come from, and that's where they like to recruit from. So depending on what law school you go to, there's law firms out there that actually sponsor half of our students.
Wow. Right?
So half of our students don't pay anything for this class. They just have to pay, travel costs and commuting costs, but that's it. Because Latham & Watkins sponsored, which is a great, the number one law firm in the world, sponsors, 75 kids nationwide, right? And it's in part because the head of their diversity and recruiting program was a former Law Preview student who did really, really well. Ended up at Latham & Watkins, decided he didn't want to practice law anymore, so he went into the administrative side. But saw it as a tool to ingratiate himself and ingratiate the firm with in the entering class at NYU, Northwestern, Stanford, and then as soon as they did it. Vincent and Elkins sponsored kids at University of Texas. And then, other firms, Morrison & Foerster sponsors kids at Bolt or at Boston College. So, the overwhelming majority of I shouldn't say the overwhelming, half of our students don't pay anything. The other half, I think the average tuition cost after all the discounts is somewhere around $1,100 if they're paying for it on their own.
But even so, it still seems to me like even if you're paying sticker.
Yeah, it's an insurance policy. And the other thing is that you have these schools that are giving conditional scholarships, right? That say basically, Steve, come to our law school. We want to give you a full ride. Condition on the fact that you finish in the top 25% of your class after the first year, you can continue to have that full ride. Which to some students are like, whoa, obviously I'm really smart. They're giving me a full ride, and then they get there and they're like, wow, this is really freaking competitive, and oh my God, you were also offered a full ride, and not everybody's going to keep their full ride. right? So there, I guess the ABA did a study of the students who were offered conditional scholarships in 2017. And not to blur you with the math, it turned out like 28% of the 1Ls who walked in with a conditional scholarship walked out of their first year of law school without a scholarship. So they're paying sticker price because they didn't make the grade second and third year, right? Which is, again, not a position that you want to be in, because ideally, presumably, right, you're offered a conditional scholarship because what the school did was they bought your number, right? They loved your LSAT score, Steve. You took your LSAT course, you killed it, all right? And now we want to buy your number because that's one number we have to report to the ABA and gets factored in the U.S. News Report and will improve our ranking. So we want to buy your score. We'll give you a 1-year tuition free at school X, and you get to keep that free tuition if you maintain this certain GPA. But because of the 1L grading curve, mathematically, everyone cannot keep their conditional scholarship. Therefore, they find themselves in a position where they either have to pay sticker price for the remaining 2 years at a school that might not have been their first choice, and they only went there because of the money, right? So they might have gotten into a higher ranked school and said, no, I'm going to go to this school because they're offering me a free ride. Well, now I'm paying full tuition for the last 2 years of law school, which again, 50 grand, right, a year. So 100 grand. And in the back of my head, I also know that all the top jobs are gone to the students who did well their first year. So, like, what do I do? Do I fish or cut bait at that point? I don't know. It's a tough question. So, yeah. So, like, when I look at Law Preview, for especially those students, I'm like, are you insane? Like, I am I might seem like a little bit of a rebel and a risk taker. I am not, all right? I am, a belt with suspenders kind of person. And somebody's going to give me that kind of an offer, to go and do something. We have a lot of students who come and say, like, I'm just simply taking this course to make sure that I maintain the minimum GPA, that I don't have to pay full freight for law school, which is a good, and we had a kid from Creighton Law School who did that. Quinn, I forget his last name. But he ended up number one in his class, but also was like, hey, the only reason why I took this is because I had a $36,000 a year scholarship, and I wanted to maintain it. And I'm like, well, you did a little bit better for yourself than that, too. It's like, yeah, it worked out pretty well.
Well, to circle back to what we were saying earlier, once again, it's about being risk averse, right?
Right.
Future lawyers being risk averse. You want to keep your scholarship. You want to keep your class rank. 1L grade's the way to do it. How do you ensure top 1L grades? Know what you're going to do before you walk in.
Right. And the other beautiful thing about it is if you plan it right, if you do it the right way, right, you might not, I was not a student who they were offering any money to. I think they looked at me when I was, and again, I was probably the crappiest student, walking into law school you could have imagined. So when it came to, my second year and I had an opportunity to transfer, there's a lot of power walking down to the Dean of Financial Aid and being like, hey, Dean, I got a problem. And they're like, what's your problem? You're number 4 in the class. You have no problem. I'm like, here's my problem. I got this letter from NYU, and Jesus Christ, they want me to come down there and finish out my 2 years there. And, immediately what the school was thinking is, okay, we lose this guy. We lose a metric that we need to report to the ABA. Are they employable within 10 months of graduation? So anybody who's number 4 in their class is going to get a job, secure a job the summer after their second year of law school, all right? They'll have an offer walking into their third year. Also, we know that the best correlation of how well somebody does on the first try of the bar exam is their first year grades. So essentially, these two metrics are going to walk down state and go to our competitor, NYU. And just like Verizon doesn't like to lose a customer to AT&T, law schools will offer retention scholarships. So kids who, like myself, were like, they weren't offering me any scholarship money to come. They thought they were doing me a favor by letting me in the first place. These kids now are turning around and saying, hey, I got a $10,000 retroactive scholarship, right? They even applied it to my first year because they didn't want me to transfer. They wanted to retain me here. So that's another, there's so much that you can do with the commodity of a first year transcript and a good first year transcript, it's like a commodity, but it's like water, right? Like it evaporates very quickly. So you have to know how to exercise it. What do I want to use that commodity to transfer? What do I want to use that commodity to parlay myself into a really good job or a job opportunity that, frankly, you may not like working in a law firm, in a big firm, and that might not be what you want. Listen, the last thing we need is another, big law attorney. We need right now, especially right now, in the current state of affairs, like we need people who are really freaking passionate about the law and are looking to change things, please God, for the better. Like go to Washington, all right? Lock some people up down there. I won't say who, all right? But start rattling some skulls down there. That's where we need good lawyers, right? So you might think like, oh, I'm going to do public interest. It doesn't really matter how well I do my first year. Well, I'll tell you, most public interest lawyers go to big law firms to pay off their debt, right? And even if they don't go there for, I wrote an article about this on a blog, that most public interest associates spend a summer as a summer associate because they can make $40,000, right, and pay down their debt. And the last one is the most famous example of that is Barack Obama, right, at Sidley. Was a summer associate with no intention of ever practicing there. But hey, look, you want to throw some money my way? Like I'd be a fool to say no. And pay down my debt. Or a lot of folks will go there, spend a couple of years in a law firm, get some good experience, and then go and save the world. And God knows we need people out there to save the world. Which, if you have 1 second, I want to do a free plug. We have a $10,000 scholarship for. I'm a big believer that one lawyer can change the world. So we have a $10,000 one lawyer can change the world scholarship. All you have to do is write a 500-word essay about how you want to use your law degree to, and you plan to use your law degree to change the world and how $10,000 would change yours. But do me a favor, if you're going to apply for the scholarship, it's on the website. Please, please, please answer the prompt. Don't just attach your personal statement because I read all these things. And it really gets frustrating when nobody, follows the directions and or, writes 1,000 words. I'm like, no, only 500. So, anything else we got? I know I've talked a lot, so I'm happy to continue answering questions, but I don't want to take up too much more of your time. This was. It looks like you're standing. I don't know. Like I'm sitting down.
Yeah, I am standing. Just my setup over here. But this was awesome, Don. And I think this is as great a place to end it as we possibly could. One lawyer could change the world. We definitely need some more lawyers in the public interest. And Law Preview, I think, is a great way for folks to get there and make it happen. So I think the URL for you guys is lawpreview.barbri.com. Is that correct?
Yep. Or you can, even lawpreview.com will get you there as well.
Lawpreview.com. I'll put that in the chat here for folks. And I'll also email it out to everybody who attended afterwards. Don, this has been a blast. Thank you so much for sharing all your advice and wisdom on law school. I know I learned a lot, and I'm sure that everyone watching did too.
It's my pleasure. Thank you so much for having me, Steve. I really appreciate it.
Thank you, Don. Take care.
You too. Bye-bye.
Bye, everyone.